Everybody has problems in this world, but your problems in this world, you're supposed to be able to deal with that. And dealing with that, when you're looking at 20 years in prison.
Beth Martinez was handed a golden ticket, a chance to avoid prison for a violent crime involving a deadly weapon. Judge Boyd gave her one simple instruction: follow the court orders. But 4 years later, Martinez returned to court with broken promises and a pocket full of excuses. She thought tragedy would buy her sympathy. She was wrong. Facing a 20-year sentence, she tries to blame the system for her own choices. Watch closely for the moment Judge Boyd stops the pity party with a brutal reality check about what it really means to be an adult.
You understand what you're charged with is aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Yeah. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement? If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison, and up to a $10,000 fine. Did you understand?
Yes, ma'am.
According to the plea bargain agreement, there's a $1,500 fine to be probated. The state recommends deferred adjudication. There's an affirmative finding of family violence, affirmative finding of a deadly weapon, and there's to be no contact with Belinda Martinez. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
State offers State Exhibit 1 and all its attachments.
Any objections?
No objection, Your Honor.
Mr. Garza, Ms. Martinez, I'm going to show you what's entitled waiver to consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Is there anything you wish to say on behalf of your client, Mr. Garza?
Yes, Your Honor. My client is unfortunately suffering under certain stressful situations right now with respect to her youngest daughter, who is only 4 years old. The father of the child has died just recently, about a month ago, of COVID. And when the child was in my client's mother's custody, CPS got called in because the child was not being well cared for. My client's been served, of course, with probably a motion to terminate. She just got served yesterday. So she has some concerns with respect to how long the McMyoff evaluation might possibly take. And the concern that she has, of course, is being able to, try to go to court with respect to that other issue of the termination of her parental rights with regard to that youngest child. So I think more than likely what she's asking me to do is ask the court if the McMyoff evaluation can be done while she's been released, or if the court is going to want to desire to have it done while she's in custody. But I know that that's one of the concerns she wanted me to express to the court. We do ask the court to follow the recommendation. My client is 26 years old, has got a very unfortunate dysfunctional situation in her household. She has a very supportive father, but obviously, of course, she's not getting along real well with her mother. The other 7-year-old child that she has is being taken care of by the father of that child. So she has a lot of concerns with respect to making sure she gets her life on track so that she can dedicate herself a little more responsibly toward her children.
All right, so when was Child Protective Services involved in this case? Is it fairly recent? Because you're saying she just got served.
Yes, Your Honor, I think it was somewhat fairly recent. My client can probably best address that, Your Honor.
All right, Ms. Martinez, when did Child Protective Services open a case?
September 5th.
Okay, so you have a year. I've done a lot of Child Protective Service cases before. Who's your attorney?
I'm not too sure.
All right, well, the papers that you were served with should give you, if it's a legal case, it should let you know who the name of your attorney is, and that attorney, which is separate from Mr. Garza, will be representing you on that matter. How many children do you have?
2.
All right, and so are your father and mother together?
No, but my father was diagnosed with stage 4 colon cancer. So he needs help. He was actually the one who had temporary custody of my daughters while I was incarcerated. But he's too sick to take care of them. So my mother stepped in and was supposed to be taking care of him while I was incarcerated.
All right, and so your child, you said one is placed with their biological father?
Yes.
And where's the other child placed?
She's in a foster home.
Okay, so here's the thing, Ms. Martinez. My experience in the Child Protective Services world is that you need to take care of yourself before you can take care of your children. It's sort of like when you're in an airplane and they say before you put the oxygen mask on anyone that's with you, you need to put the oxygen mask on first so that you can take care of the people who are with you. Because if you fall down, then you're not going to be able to help the next person, okay? So the conditions I'm going to set for you are going to be things that hopefully you will complete and it will help you. Now, the conditions that I set, if Child Protective Services sets the same sort of conditions, which I think they will, the court will accept those conditions for what I'm asking for, because I'm going to ask for parenting classes, but I know Child Protective Services is going to request that as well. It's going to be very important that you stay in contact with your CPS attorney and stay in contact with Child Protective Services. Understand?
Yes, ma'am, I do.
I always think that a year is a long time away, but a year goes by quickly. And you don't want to look up 6 months in and you haven't done anything, okay?
Okay.
All right, so this is what the court is going to do. 4 years deferred adjudication, $1,500 fine, that will be probated. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Belinda Martinez, 80 hours of community service restitution. That will be waived if you successfully complete all CPS requirements. I'm going to want a mouth evaluation. That will be while you're in custody. And here's the thing about that. Child Protective Services are probably going to have you evaluated as well. And Rebecca, if their evaluation is completed before the mouth, and if that's acceptable to probation, we'll go with CPS evaluation. The BIPP course, parenting classes, regular Zoom reporting or in person, field visits 2 times per month. Where are you going to be staying if you're released?
At my grandmother's.
All right, does your grandmother want you there?
Yes.
What is your grandmother's name?
Esther Martinez.
Okay, you're to reside with Esther Martinez upon release, CPS compliance, random UAs, field visits, 2 times per month, random. All right, with that, we'll close the record. Ms. Martinez,
Yes, ma'am.
this is what I'm going to tell you. You need to start taking care of yourself. From here on out, everything you do, if you want custody of your child back, you're going to have to focus on doing what's best to potentially obtain custody of your child back. You understand?
Yes, ma'am.
I know you may think this may seem harsh, but remember, we're all on a journey. Where we start at is not where we're going to end in our journey in this life. So hopefully, as we go along, we're improving ourselves, okay?
Yes, ma'am.
Are you the same Beth Nicole Martinez who's placed on deferred adjudication in 2021 CR 8476 for the offense of aggravated assault with a deadly weapon on October 12, 2021 for a period of 4 years? Is that you?
Yes.
All right, state.
Yes, state's going to proceed on violation of condition number 2 on or about the 7th day of October 2024 in Bexar County, Texas. The defendant, Beth Nicole Martinez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
The state will waive the remaining violations.
No objection.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes.
Knowing that, will you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there proposed agreement?
Partially, Your Honor, the agreement was for her to plead true to violation of condition number 2. I do believe defense and I both have different recommendations. The state's recommendation is that she receive some sort of inpatient treatment given the positive UA and the failures to submit. But I do not see any evidence of mental health directives. I mean, the only thing we have is going back as far as 2021. I don't have any current on that to show that there's DPRF.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 UA, it was either September or October, the October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like running like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite complete it up. Now we're gonna have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
So here's the thing I know about felony drug court, because I used to be an attorney for felony drug court. All you had to do was pick up the phone and call them.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there, and the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing, it's not about whether or not you can do a fundraiser. It's about, I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my UAs. I may fall out of this program. That's what it's about. It's not, I'm struggling. I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just gonna stop submitting the drug testing. I'm not gonna do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did good the whole time I was on it.
So let me ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager and it wasn't working. So your response to that was to do what with your probation?
Mhm. At the time I was with someone, I had too much stuff going on. I was losing
All
my
right, so
father's house.
your decision with probation was what? With felony drug court? See, I'm trying to get you to point, because see,
Well, I know where I messed up. I'm not saying I didn't.
yeah, but so that's the thing. You didn't learn anything from felony drug court, because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping, everything's going well. I get a call at 3 a.m. It's a Monday, I get a call at 3 a.m. And you know what that call is? It's from my younger brother, and guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why did you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left messages to everybody, hey, my grandmother just died. I'm going to have to go home. So I tell you that to say everybody has problems in this world, but your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not going to do that, then you got to accept that. You're on paper. That's what we called it when I was a defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is from 2021. I do not see, I don't have any information.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm gonna give you a choice. I can deny the motion. You're not getting out of jail today. You're going to do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long, and that's the right choice.
Will I get my back time if I sign up?
Sure. So what do you want to do?
Do the TAP evaluation.
All right, so the court will deny the motion, alternate amend conditions to include in custody. There's to be a TAP evaluation. Follow all recommendations. And there's also to be an updated MIC evaluation in custody. And is there anything else that's being requested, State?
No, Your Honor.
And is there anything else you need from the court? Miss, is there anything else you need from the court?
Amen.
All right, and there's to be no residents with minors. All right, thank you.
Beth Martinez wanted the court to bend the rules because life got hard. But as Judge Boyd pointed out, everyone has a bad day. Everyone suffers loss. That is not a permission slip to ignore the law, especially when you're already on thin ice for a violent crime. Martinez asked for freedom and outpatient treatment. Instead, she's staying in custody for a full evaluation. She gambled on the judge's sympathy, but she forgot that accountability comes first. So what do you think? Was Judge Boyd too harsh on a grieving mother? Or was this exactly the tough love Martinez needed to finally grow up? Let us know in the comments below, and don't forget to subscribe for more real justice.